Okay, but parodies. Are we allowed to do this as entrepreneurs to have fun on social media, to promote our businesses and more? Parodies are fun little twists on things that everybody knows, but there is a right and a wrong way to do it, and you want to make sure that you are not getting yourself in legal trouble if you're jumping into the world of creating parodies. So today we're talking to everybody's favorite IP and entertainment lawyer, Tony, to learn more to keep you legally protected as you go forth and be funny in this industry.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called the IP Professor that is dedicated to all things intellectual property.
I want to talk a little bit this week about parodies and what entrepreneurs can and can't do to legally make them. So, Tony, what do we need to know about parodies?
So I think the first thing to know is parody is a type of criticism or commentary that our court system has recognized as something that is applicable to fair use, at least on the prong when we're talking about copyright fair use, which more times than not is where a lot of people are going to exercise the whole parody argument, if you will. So parody, as it's been defined in our court system to constitute a parody, for purposes of establishing a fair use defense to copyright infringement, a work must be directed at least in part at the original, and its commentary must have a critical bearing on the substance or style of the original. And this is coming straight from case law that has been long established on this point. So, what's important to note about parody is that, it doesn't necessarily have to poke fun at something, but it does have to provide some type of unique, sensible commentary that maybe is generally in nature funny. It could be humorous, if you will, or draw a laugh, but it doesn't necessarily have to be making fun of something. And one of the penultimate cases that has clearly laid out the whole point of parody and especially how it goes tandem with fair use is the Campbell versus Acuff Rose music case that went all the way to the Supreme Court in the early 90s. This case involves the iconic Roy Orbison song "Oh Pretty Woman" that we all know from the movie Pretty Woman with Richard Gere and Julia Roberts. Shameless plug. But then that song has a very distinct style to it. Everybody knows that very distinct bass, do 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 do, and then it goes into the rest of the song. But the bass is like what makes that song so memorable. If you just heard that, you know that you're listening to Pretty Woman. So Two Live Crew was a rap band in the late 80s, early 90s that was interested in doing a song that sampled the Roy Orbison "Oh Pretty Woman" song. So they went to Roy Orbison's record label. He and the label denied it, and Two Live Crew and Skywalker Records, their label, still went ahead and made the song anyway that features the "Oh Pretty Woman" song. Obviously, what they did was they transformed the work itself. They made their own version of the bass line at the start of the song, and they did take the lyrics and they did transform them to be more akin to what they wanted to talk about in terms of their perspective of romanticism in the 90s. So, of course, Roy Orbison, Billy Dees, his co-writer, up in arms. They filed a copyright infringement lawsuit against Two Live Crew. Two Live Crew claimed the defense of copyright fair use. This goes all the way to the Supreme Court, and the Supreme Court found that the lyrics were transformative in nature because there was almost like this new expression, meaning, or message associated with it. The criticism that was contained in the Two Live Crew song in some way is almost like talking about how romanticism in the 90s is drastically different from romanticism in the 60s. The Two Live Crew song alludes to catcalling and different shapes of women, something that is not akin to the Roy Orbison song in any way, shape, or form. So that case really was the penultimate case on fair use and parody. One thing to note also about fair use operates always as a defense to copyright infringement, so long as you're using it for criticism, commentary, news reporting, teaching, scholarship, or research. So in this case, when you have something that is clearly criticism and commentary of this sort, you can see why the fair use defense operates in favor of Two Live Crew here. There's a 4-factor test, I should add, also under the fair use doctrine, that you don't need to satisfy all four factors. One factor is not dispositive of the other, but it is used in an assessment that essentially moves the needle for in favor of fair use or against fair use, depending on how strong or weak those factors would be in a singular case. So it's not a cookie cutter model that's always going to apply to every single fair use case. It's just fact specific. And the Supreme Court found that all the other factors sucked, but for whatever reason, the purpose and character of the use touching on the transformative nature of Two Live Crew's song, touching on the fact that it was a criticism by way of a parody. All of that, in their eyes, that one factor was enough for the Supreme Court to rule in favor of Two Live Crew, ruling it not as copyright infringement, but more so as its own independent copyright that is worthy of protection. So really, really important case law on this point. If I'm bringing it back home, I think that this case really highlights how, if you're interested in doing parodies, think thoughtfully and conscientiously. Are you providing some type of criticism or commentary? Are you using an original in some capacity? Are you transforming it in some way? Everybody thinks that transformative fair use is separate from fair use. That's not. It's not the case. Transformative fair use is a sub-prong under the fair use doctrine. It touches on the purpose and character of the use. Have you transformed the original work in such a way that it has, what you've created has new expression, meaning, or message? That is the heart of the transformative fair use argument. Look at how much of the original copyrighted work are you using. Are you using a small portion of it? Or are you using the entirety of it? All of these factors are very fact specific. So it's all going to depend on how a court would rule based on the facts that are present in your specific situation. But of course, with any matter that deals with fair use, if you're not an expert or learned on the subject matter, always consult with a lawyer, because fair use, like I said, operates as a defense. So if you are sued for copyright infringement, you will have to raise a defense of fair use, but it's a matter of how good and how strong your fair use defense is even in the first place.
And let's say we create a parody and we put it out on the internet, we put it out for public consumption, and somebody does come to us claiming copyright infringement. What are the next steps to take?
So contact the lawyer first, because when you get that claim of copyright infringement, you need to know what the attack strategy is. Do you respond to that cease and desist? Do you respond to that claim? Gather as many facts as possible in discovery, I guess, if you want to call it that, alongside a lawyer. Sharing whatever information you may have that may be essential for the lawyer to respond in correspondence. And basically from that point, it's essentially a wait and see approach. From moment of discovery of an infringement, the person that is claiming copyright infringement has 3 years to pursue a claim and, fully go all in and file an index number and file a lawsuit. One of the other questions that's also going to pop up here is the person that's claiming copyright infringement also, do they allege that they registered the copyrighted work? You can't bring a copyright infringement claim without having that work, that origin work, registered in the U.S. Copyright Office. So that may be essential to this discovery phase, if you will, where your lawyer would have to ask, well, you're claiming copyright infringement. Can you provide proof of copyright registration? And if they can't, then that's going to be probably something that could work in your favor. You're buying a little bit of time, certainly, but also maybe you're calling the bluff of the person that's claiming infringement. Now, if they are the true copyright owner and then they wait and file and register the copyright in full in the U.S. Copyright Office, and you get slammed with a complaint, then it's at that point where, again, working alongside with your lawyer and providing as much information is going to be helpful, because then the lawyer is going to help craft a good, solid argument for fair use, hopefully if it's valid. And sometimes it may just end in a settlement, but if you feel strong in your convictions that you can fight it out, fight it out. I will say this, though, this is what I've learned in law school: 90% of cases always end in a settlement. So if you do have the option to settle, that's not an admission of guilt, and that is certainly not an admission that you did anything wrong. It's just a way to just clean up the mess and move it along. And trust me, lawsuits are long and lengthy and very expensive. So you're just better off just, if you have the option handed to you to settle, take it, consider it, and move it along.
That makes a lot of sense. So as we're moving forward with this, if you are creating a parody for social media, make sure that you are being aware that you are adding critique or commentary to this, that you're doing it the right way. If you're doing something that's a little bit of a larger scale, you may want to consult a lawyer first and make sure you have those conversations to make sure your script or whatever you're planning really does fall within the lines of fair use. And of course, if you end up with any trouble over this, contact your lawyer and have them help you through this process. If you got questions on creating parodies as an entrepreneur to create something really cool for your social media or to grow your business or to grow that awareness or to have those conversations in your community, go ahead and drop the questions. We want to make sure we're getting those answered for you as Tony comes back for upcoming episodes. And as always, if you have questions in the entrepreneurial space that you need legal assistance on or guidance on, drop the questions. Tony is here to get those answered for you, and we can always reach out to him on his social media. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor, and you can check out my podcast, End Scene, and Entertainment Law Podcast, every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Have more questions on the legal side of entrepreneurship? Drop them down below because Tony is coming back for even more episodes to keep you legally protected in the entrepreneur space. And hit that subscribe and notification bell because every single day we are dropping videos to help you navigate the world of social media content creation, being profitable online, building your business, and making sure that this is your most profitable year ever. So drop your questions on entrepreneurship down below and we'll get those answered for you in upcoming videos, and we'll see you in our next episode.